Ms. Tatro, we'll turn to you next.
Morning, my name is Emily Tatro. I'm Deputy Director with the Council for Court Excellence, and I will pick up where John left off. CCE has several specific recommendations for the bills in our written testimony, but I'm going to highlight 4 this morning. Waiting periods for sealing convictions, automatic sealing for non-convictions, retroactivity, and exceptions for research and journalism. First, waiting periods. CCE supports a 3-year waiting period for sealing misdemeanor convictions and a 5-year period for felonies. At least 19 states already adhere to these timelines. Robust research shows that people who remain crime-free for 3 to 4 years after a nonviolent conviction and 4 to 7 years after a violent conviction are no more likely to recidivate than a member of the general community. DC's waiting period should be in line with the evidence and take into consideration the burden imposed on pro se movements by imposing a different waiting period for each type of conviction. Automatic sealing. We strongly support automatic sealing of records in all cases terminating without a conviction. About half of the estimated 68,000 DC residents with a criminal record have no record of a corresponding conviction within the prior decade. That means that 35,000 people face real ramifications when applying for jobs and housing, despite an arrest or charge not having led to a finding of guilt. To fully uphold the constitutional principles of our justice system, the burden must not be on the movement to seal an arrest for which no guilt was established. CCE recommends instead automatic sealing for all non-convictions, with the prosecution retaining the option to file a motion in opposition if they see fit. As for retroactivity, given the barrier that a criminal record can play in a person's life, CCE believes that changes to DC's criminal record sealing statute must apply retroactively. Just as the DC Code allows movements to petition for retroactive sealing of now decriminalized or legalized offenses, changes to sealing of non-convictions should apply with fairness to individuals, past or present, who seek relief. And then finally, the exception for research and accountability. Legislation must assure that the 2 kinds of public interests here remain in balance. DC's interest in limiting the collateral consequences of justice involvement for individuals, like we've been talking about today, must be considered alongside the public interest in transparency and accountability for the judicial branch of our democracy. That second interest has a long history of protection by the courts to assure that proceedings are not secret and that the court operations are visible to the public. And this extends to include access to bodies of records. Indeed, the Urban Institute sets research that John cited at the opening of our testimony that we rely upon to know how many people in this city have criminal records wouldn't have been possible if court records weren't publicly available. So we're requesting that language carving out an exception for sharing de-identified records for research or journalistic purposes be included in any record sealing bill. This is not a record that would be attached to an individual name, but records that can be anonymized, de-identified in order to look at the overall impact of the system. We urge the council to act quickly to pass new record sealing and expungement scheme before people with criminal records, who we know are mostly our Black neighbors, are pushed to the back of the line as the economy begins to reopen and evictions begin to happen. Thank you for your time, and we welcome any questions you have.
Thank you very much. Appreciate that, Ms. Tatro. Next up.